Good evening. Global pop superstar Katy Perry is tonight at the centre of a police investigation over bombshell claims of sexual abuse inside a Melbourne nightclub.
This is a general legal explainer on the structural differences between defamation law in Australia and the United States. It is meant as background education on two legal systems that have come up in coverage of various celebrity disputes, not as commentary on the merits of any specific case, and not as legal advice. At its core, every defamation system in the common law world, the family of legal traditions that includes the US, Australia, the UK, and Canada, is trying to strike a balance between two competing values: a person's interest in protecting their reputation from false and damaging statements, and society's interest in free expression, including the ability to criticize, report on, and hold public figures accountable. Different countries have drawn that line in very different places, and the US and Australia sit at almost opposite ends of the spectrum. In the United States, defamation law has been shaped heavily by the First Amendment and a landmark 1964 Supreme Court case, New York Times Company v. Sullivan. That case established what's known as the actual malice standard for public figures and public officials suing over statements related to their public conduct. Under this standard, a public figure who sues for defamation doesn't just have to show that a statement was false and damaging. They have to prove, with clear and convincing evidence, that the person who made the statement either knew it was false at the time or acted with reckless disregard for whether it was true or false. This is a demanding standard. It's not enough for a statement to be wrong, careless, or even the product of sloppy fact-checking. The plaintiff has to show something close to intentional or willfully blind dishonesty. This standard exists because U.S. courts have generally treated public debate about public figures, politicians, celebrities, executives, and others who have entered public life as something the legal system should be reluctant to chill. The concern is that if it were too easy for public figures to win defamation suits, journalists, critics, and ordinary citizens might self-censor out of fear of being sued, even when they had a good faith basis for what they said. In practice, this means that in the U.S., defamation suits brought by celebrities or public officials against critics, journalists, or accusers are difficult to win, and many are dismissed relatively early in the legal process because the plaintiff can't clear the actual malice bar. It doesn't mean such suits never succeed. There have been notable exceptions, but the deck is generally stacked in favor of the person who made the statement, provided they weren't lying outright or being recklessly indifferent to the truth. There's also a related concept in U.S. law. Truth is generally treated as an absolute defense, but the burden of proving falsity generally rests with the plaintiff, not the defendant. Combined with the actual malice requirement for public figures, this creates a fairly steep uphill climb for any well-known person trying to sue over public commentary or accusations. Australian defamation law works quite differently, and the difference is structural rather than just a matter of judicial interpretation. Australia does not have a First Amendment equivalent constitutional free speech guarantee in the same form as the U.S. Instead, defamation in Australia is governed primarily by a set of uniform state and territory laws, the model defamation provisions, which have been broadly harmonized across most Australian jurisdictions, including Victoria, after a round of reforms. The key structural difference is where the burden of proof sits. In Australia, once a plaintiff shows that a statement was published and was defamatory, meaning it would tend to lower their reputation in the eyes of ordinary members of the community, the burden shifts to the defendant to prove that the statement was substantially true or that some other recognized offense applies. This is close to the reverse of the U.S. system, where the burden generally sits with the plaintiff to prove the statement's falsity and, if they're a public figure, the defendant's state of mind. This means that in Australia, someone who makes a public accusation and is then sued for defamation may find themselves in the position of having to prove in court that what they said was true, rather than the accuser, the plaintiff, having to prove it was false. If the defendant can't establish truth or another valid defense, they can lose the case, even if they genuinely believed what they said and had no intent to deceive anyone. This structural difference has real consequences for where public figures choose to bring defamation claims, particularly when a dispute has some connection to more than one country. For instance, if the parties involved have public profiles in both the US and Australia, or if some of the underlying conduct or statements touch both jurisdictions. Because Australian law places the burden on the person being sued to prove truth, it has become, in general commentary among media lawyers, a comparatively favorable jurisdiction for plaintiffs, including public figures, to bring defamation claims compared to the US. This dynamic has sometimes been referred to informally as libel tourism, a broader phenomenon, most associated historically with the UK, which has similar plaintiff-friendly features, in which people with the means to sue in multiple countries choose the jurisdiction whose laws are most favorable to their position. Australian courts have handled a number of high-profile defamation cases involving public figures and media organizations in recent years, and outcomes have varied considerably depending on the specific facts, the strength of each side's evidence, and whether truth or another defense could be established. The fact that a jurisdiction has plaintiff-favorable procedural rules doesn't mean every plaintiff wins. Australian defendants have also successfully defended defamation claims by proving the substance of what they said, or by relying on other defenses, discussed below. Truth, called justification in some formulations, isn't the only defense available to someone accused of defamation in Australia. Other recognized defenses under the harmonized model defamation provisions include honest opinion, a defense that can apply when the imputation was an expression of opinion, rather than a statement of fact related to a matter of public interest and based on proper material. Qualified privilege, which can apply in certain circumstances where the person publishing the statement had a legal, social, or moral duty to make it, and the recipient had a corresponding interest in receiving it, provided the statement wasn't published with malice. Public interest, a relatively more recent defense, introduced through defamation law reforms in several Australian states, including Victoria, modeled partly on similar reforms in the UK, which can protect a publisher who reasonably believed that publishing the material was in the public interest, even if they can't establish its truth outright in court. Contextual truth, which can apply when some, but not all of the imputations in a statement are proven true, and the untrue parts don't further harm the plaintiff's reputation beyond what the true parts already establish. These defenses mean that Australian defamation law, while structurally more plaintiff-friendly on the burden of proof question, is not simply a one-way street favoring anyone who sues. A defendant with strong evidence, credible witnesses, or a good-faith public interest basis for what they said still has real avenues to defend a claim successfully. Australian courts have seen a number of prominent defamation disputes over the past decade involving actors, media personalities, and public figures, which is part of why the jurisdiction has developed a reputation in entertainment and media law circles as a venue where celebrities have pursued claims relating to public allegations against them. Outcomes in these cases have varied. Some plaintiffs succeeded and were awarded damages, while in other instances, defendants successfully proved the truth of what they'd published or established another defense, resulting in the claim failing. Because the specific facts, evidence, and legal arguments differ enormously from case to case, it isn't meaningful to draw a general conclusion from Australian defamation cases involving celebrities as a category about how any future or ongoing dispute will resolve. Each case turns on its own evidence. When a defamation dispute arises out of a sexual assault allegation, as opposed to, say, a dispute about business conduct or a political statement, there's an added layer of complexity. If a person publicly accuses someone of assault and is then sued for defamation, proving truth as a defense in Australia would generally require presenting evidence sufficient to satisfy a civil court on the balance of probabilities that the assault occurred. That's a different, generally lower, evidentiary standard than what would be required for a criminal conviction, which in Australia, as in most common law systems, requires proof beyond reasonable doubt. This creates an interesting dynamic. A criminal investigation and a civil defamation case can proceed on parallel but separate tracks with different standards of proof, different courts, different possible outcomes, and no requirement that one track wait for the other to conclude, although in practice courts sometimes manage overlapping proceedings carefully to avoid one process unfairly prejudicing the other, for instance, avoiding a civil trial that might taint a jury pool for a related criminal matter, or vice versa. Separately from the substantive legal analysis, choosing whether to file a defamation suit is a strategic decision for any public figure, for reasons that go beyond simply whether they think they'd win. Filing a defamation claim opens a legal process called discovery, in which each side can be compelled to produce internal records, communications, and witnesses relevant to the dispute. This cuts both ways. It could allow a plaintiff to compel evidence supporting their position, but it also exposes the plaintiff's own records, communications, and personal conduct to scrutiny by the opposing side's lawyers, and potentially to becoming public through court filings. This is a well-established general dynamic in defamation litigation across jurisdictions, not something specific to any one case. Public figures sometimes choose not to sue over public allegations, even ones they dispute strongly, because the discovery process and prolonged public trial could create more reputational and legal exposure than simply issuing a denial and declining to litigate. To boil it down to the single clearest distinction, in the U.S., a public figure suing for defamation generally has to prove the statement was false and made with actual malice, a standard that makes such suits hard to win. In Australia, once a statement is shown to be defamatory, the burden shifts to the person who made the statement to prove it was true or otherwise legally justified, a standard that makes such suits comparatively easier to bring and, in some circumstances, easier to win, provided the plaintiff can show the statement caused reputational harm and the defendant can establish a valid defense. This difference is a matter of public record and general legal knowledge. It applies to any defamation dispute involving these two jurisdictions, regardless of the individuals or facts involved, and understanding it is useful background for interpreting media coverage of legal threats, denials, or potential lawsuits involving public figures with ties to both countries. This is general legal information, not legal advice, and none of it should be read as a comment on whether any lawsuit is likely, appropriate, or would succeed in any specific real-world dispute. If you want, I could also put together a plain language explainer on how civil and criminal proceedings can run in parallel in a common law system, since that's a related concept that sometimes causes confusion in coverage of cases like this.